Asmita Mitra, a law student of Surendranath Law College, would like to speak on a topic on Nikah of Muslim law. So, marriage, that is Nikah, in pre-Islamic area means different forms of sex relationship between a man and a woman, which is established in certain forms. So, in pre-Islamic days, women were treated as chattels and they were totally dependent on men, and even they did not get a proper right for inheritance. But when Prophet Muhammad came, he brought a complete change in the position of women, and he gave the equally same position of men to women. And that we will also find in Hidayah, page number 25. So now let's look up to the definition of Nikah. So what is Nikah? Nikah is an Arabic term which literally means the union of sexes, and in law this term is known as marriage. So in Bailey's Digest, marriage has been defined to be a contract, the purpose of legalizing sexual intercourse and procreation of children. Now let's get a small view from some of the jurists about Nikah. So first, Abdul Rahim, one of the famous jurists, says the Mohammedan jurists regard the institution of marriage as partaking both of the nature of ibadat or devotional acts and mubarat or dealings among men. So according to Justice Mahmood, marriage among Mohammedan is not a sacrament but just a civil contract. Now regarding this statement, there are two types of arguments. One which supports this statement and the other which contradicts this statement. So first we will study about the jurists who support this system. So many text writers and jurists treated it as a mere civil contract and not a religious sacrament. This observation is based on some facts where the marriage has got very similar characteristics with a civil contract, as marriage required proposal and acceptance, that is ijab and kabul, from the other, so is in the contract. As we have learned in the contract that acceptance and proposal is a very valid essential of a valid contract. Moreover, there can be no marriage without free consent, such as the consent should not obtained by any means of coercion, fraud or undue influence. So same happens in a civil contract. Number 2, just in case of contract entered by a guardian or attaining majority, so can be set aside by a minor on attaining the age of puberty. So same thing happens with a civil contract. Now the point number 3, although discouraged both by the Holy Quran and Hadith, yet like any other contract, there is also a provision for the breach of marriage contract. So here we can find that there are a lot of similarities which proves that it is Muslim marriage is a civil contract but not a religious sacrament. So now we'll discuss about the contradict part of this statement. Justice Mahmood observed that marriage is a civil contract, but it cannot be appreciated only because to the some extent marriage resembles with civil contract. If we minutely observe that, we will find that besides some of the similarities, there are a lot of differences that proves that it is not a civil contract but a religious sacrament. So Muslim law is not merely a civil contract because there are 2 points right now I can show you. The first one is the unlike civil contract, it cannot be for a limited time. And the second one, Obviously, muta marriage is an exception. And the second point, unlike civil contract, it cannot be made contingent or future event. So, there are more reasons where we can say that marriage under Muslim law is a religious sacrament. So, some of the jurists also tried to put a more balanced view of the Muslim marriage. What's that? By holding it both a civil contract and a religious sacrament. So next we'll know about the objects of marriage. So a glossary on Tirmizi sets out 5 objects of marriage. The first one is the restraint of sexual passion. The second one is the ordering of domestic life. And the third one is the increase of the family. The fourth one is the discipline of the same in the care and responsibility of the wife and children. And the fifth and the last one is the upbringing of virtuous children. So Hidayah also speaks of the ends of marriage. What are the 3 points? First one is the cohabitation. The second is the equal friendship. And the third is the society. So now we'll talk about the essentials of a Muslim marriage. Means the essentials, without the essentials, a Muslim marriage cannot be successfully done. So the solemnization of marriage requires adherence to certain forms and formulas. Those are known as essentials of a valid marriage. And in short, the essentials are as follows. There are 3 essentials of a Muslim marriage. The first one is the proposal and acceptance, and it is a very important essential. And the second one is the competent parties. And the third one is the no legal disability. So first we'll talk about the proposal and acceptance. So proposal and acceptance has also been divided into different factors. 7 important factors. So the first factor of proposal and acceptance is marriage is like any other contract, is constituted by ijab or kabul, that is by declaration and acceptance. We have already said that ijab and kabul means proposal and acceptance is very important in a particular Muslim marriage. So here we are again getting the same viewpoint that in Muslim law, ijab and kabul, that is proposal and acceptance, is very important. So the one party makes an offer, that is ijab, to the marriage to the other. The marriage becomes complete only when the other party has accepted the offer. So according to Muslim law, it is absolutely necessary that the man or someone on his behalf and the woman or someone on her behalf accepts or agree to the marriage at one meeting, and the agreement should be witnessed by 2 adult witnesses. So the second factor of proposal and acceptance is there must be no ambiguity. Absolutely no ambiguity. The words must indicate with reasonable certainty that a marriage has been contracted, where the words of offer and acceptance are laid down in a written document which is known as Kabir Nama, an important documentary evidence of marriage in Muslim law. So, the third factor about this proposal and acceptance is the words conveying proposal and acceptance must be uttered in each other's presence, in the presence of their agents who are called wakils. So, the fourth factor is one meeting. We have already talked about one meeting, and here we'll talk about it again. So, in one meeting, the proposal and acceptance should be done, and this is very important. So the one most important factor is that the transaction must be completed at one meeting. Now the fifth point is the reciprocity. There must be reciprocity between the offer and acceptance. The acceptance must not be conditional. There is no reciprocity between offer and acceptance, and therefore there is no marriage. So the sixth factor is witnesses. Under Sunni law, the proposal and acceptance must be made in the presence of two males and one male, or one male and two females witness are, and they should be properly sane, of sound mind, and the absence of witnesses will not make the marriage void but irregular. But this is in Sunni law. But in Shia law, witnesses are not necessary at the time of marriage. Now the seventh and the last factor of proposal and acceptance, that is free consent and will. The parties contracting a marriage must be acting under their free will and consent. The consent should be without any fear, fraud or undue influence. So consent is very essential factor in a marriage, and the father's consent is not considered, absolutely, I mean to say, I should repeat it, absolutely not considered substitute for the girl's consent. So now we'll talk about the second essential of Muslim marriage, that is competent parties. So competent parties also consist of four important factors. That is, the first one, as we have all studied in contract, that age is a very important factor, and the bride and the bridegroom should have the proper age and should have the capacity to enter into the contract. So a Muslim who is of sound mind and who has attained puberty can be able to enter into a contract of marriage. So the next factor comes, that is puberty. So puberty means the age at which a person becomes able to perform sexual relationship, means sexual intercourse and procreation of children with her husband. So puberty and maturity is the same according to Muslim law. A female cannot get married before attaining puberty. The third factor in marriage of minors, is marriage of minors. So, and guardianship in marriage. So it should be noted that the marriage among a minor without the consent of the guardian is void unless it is ratified after the attainment of majority. So the guardian in marriage is known as Jabr. The right to contract to give a minor in marriage belongs successively to the following persons. The first one is the father. The second is the paternal grandfather of highsoever. Number 3 is the brother or other male relations of the father's side. Number 4 is mother. And number 5 is the maternal uncle or aunt and other maternal relations without the prohibited degrees. And the sixth and the last one is the state. So if a girl doesn't have any of these above mentioned family relations, then the state will decide. So but under Shia law, only the father and the paternal grandfather, how highsoever, are recognized as guardians for contracting marriage of minor. So the fourth point and the last factor of competent parties is the known of Khair ul Buluk, that is the option of puberty. In certain circumstances, a minor contracted in marriage by the guardian for marriage has the right of ratifying the marriage contract on attaining puberty. So this right of a minor is known as the khair ul bulugh, or the option of puberty. So that we have understood that a girl, if she is minor and got married to someone, but when she'll get when she'll attain puberty, she has her personal right to decide that whether she really wants to live with that person or not. And if she doesn't, that means she can choose the option of puberty. So now we'll come up to the last and the third essential of Muslim marriage, that is no legal disability. So legal disability means the existence of certain circumstances under which the marriage is not been permitted. So these prohibitions have been classified into 4 classes. So what are they? The first one is the absolute incapacity or prohibition. The second is the relative incapacity. The third is the prohibitory incapacity, and the fourth and the last one is the directive incapacity. So first we'll talk about absolute incapacity. Absolute incapacity is also divided into 3 parts. The first is the consanguinity, that is curabat. So consanguinity means the blood relationships and bars a man have from marrying. So what are the relationships a man cannot get married to? So the first one is his mother or grandmother, how high soever. The second is his daughter or granddaughter, how low soever. The third is his sister, whether full, consanguine or uterine. The fourth is his niece or great niece, how low soever. And the fifth is his aunt, means the father, sister or mother's sister or great aunt, how high soever, whether it be a paternal aunt or a maternal one. So this is a marriage with a woman prohibited by reason of consanguinity is void. If this kind of marriages happen, then they will be known as illegitimate. So the second factor, means the second point, is affinity. Affinity is also known as musharat. So a man is prohibited from marrying again different relationships. What are they? We'll see. His wife's mother or grandmother, how high soever. His wife's daughter or granddaughter, how low soever. Wife of his father or paternal grandfather, how high soever. And the last one is the wife of his son or sons or daughters, how low soever. Pardon me, please. Now the third is the fosterage, means that is known as riza. When a child under the age of 2 years has been suckled by a woman other than his own mother, then the mother becomes his foster mother of the child. A man may not be able, for instance, to marry his foster mother or her daughter or the foster sister. So there are some exceptions under Sunni law. There are a few exceptions to the general rule of prohibition on the ground of fosterage, and that we cannot be a valid marriage may be contracted with sister's foster mother or foster sister's mother or foster son's sister or foster brother's sisters. So the Shia jurists place fosterage and consanguinity on the same footing. Why they put consanguinity and fosterage at the same footing? Because the mother who is taking care, in spite of not giving birth to that son, is also a mother of that child. So they refuse to recognize the exception that is permitted by the Sunnis. So the above mentioned prohibitions on the account of consanguinity, affinity or fosterage are absolutely means are very much absolute, and the marriage contracted in this contravention of these rules are totally and absolutely void. So now we'll come up to the second legal disability, that is relative incapacity. So relative incapacity springs from cases where they render the marriage invalid. Means in some circumstances that we can say that a Muslim marriage is not valid. So there are 5 following cases where there is relative incapacity. The first one is the unlawful conjunction. The second is polygamy or marrying a 5th wife. The third is absence of proper witness. The fourth one is the differences of religion, and the fifth one is the women undergoing iddat. So first we'll talk about unlawful conjunction. Unlawful conjunction, it means it means marrying 2 women unrelated to each other by consanguinity. As we have already learned that consanguinity, affinity and fosterage, here are the 3 important relations with whom Muslim cannot get married to. But if the person does that, then the Muslim marriage should be said void. So thus a Muslim cannot marry 2 sisters or an aunt or her niece. So the second point comes is the polygamy or marrying a 5th wife. So it means plurality of wives, that is marrying a 5th wife is unlawful in Muslim marriage. It is unlawful for a Mohammedan person to have more than 4 wives. So marriage with a 5th wife is irregular, but this marriage with the 5th wife is not merely irregular, it is void. It's totally void. You need to divorce any of your 4 wives to get married to this another woman. 5th wife is totally illegal over in Muslim marriage. So the third is the absence of proper witness. It is essential among the Sunnis that at least 2 males or a male and 2 females must be present when the marriage is being testified. When the 2 persons get into the marriage. So if this essential is not been followed properly, then we can say that there is a relative incapacity in marriage. So the fourth factor is the differences of religion. So a Sunni male can marry a Muslim female or a Kitabiya. But marriage with a Kitabiya, that is a woman who believes in Christianity or Judaism, is valid under Sunni law. But a marriage with a different religion women is totally void in Shia law. So under Shia law, no Muslim, whether be a male or a female, can marry a non-Muslim. So the fifth point and the last point of relative incapacity is women undergoing iddat. So what is iddat? Iddat is the period during which it is incumbent upon a woman whose marriage has been dissolved by divorce or death of her husband the women has to remain in seclusion and to abstain from marrying another husband. So there is a definite proper time after which that period is known as iddat, that after which the women can marry again another man. So Amir Ali said that an interval which the woman is bound to observe between the termination by death or divorce of one matrimonial alliance and the commencement of another. So under Sunni marriage with a woman undergoing iddat is irregular and not void. But under Shia law, marriage with a woman who is undergoing iddat is totally void. So there are different duration of iddat. Some iddat of widowhood, some widowhood iddat, the expiration of that period is 4 months and 10 days. Iddat of pregnant woman is observed 4 months and also 10 days, is the same. So there are different kinds of period for attaining iddat, means for the attaining iddat, yeah. And the fifth and the third disability is the prohibitory incapacity. So prohibitory incapacity also consists of two important factors, that is polyandry and Muslim woman marrying a non-Muslim. So polyandry means the factor of having more than one husband. So the polyandry is forbidden in the Muslim law system, and marrying a woman who cannot married women cannot marry another man second time as long as her first marriage is subsidy. So the second is the Muslim woman marrying a non-Muslim. A marriage of a Muslim female with a non-Muslim male, whether he be a Christian or any kind of other religion, so it is irregular under Sunni law but void under Shia law. So the fourth and the last legal disability is the directory incapacity, which consists of the four factors, that is marrying a woman who is incenti and prohibition of divorce. The third one is the marriage with pilgrimage, during pilgrimage, and marriage with a sick man. So marrying a woman who is incentive is unlawful to marry a woman who is already pregnant and by her former husband. So the second one is prohibition of divorce. As we have already learned that the marriage is dissolved by the pronouncement of divorce 3 times, reunion is prohibited except after the lawful marriage of the women with another man, and then the marriage should also be consummated. So the third is the marriage during pilgrimage. So under Shia law, marriage during pilgrimage is totally void, but in a Sunni law it is irregular. So and the fourth but the last point is marriage with a sick man. Marriage with a sick man suffering from disease which is fatal is invalid. So if however he recovers, the marriage will get consummated and then it will get valid. So today I would like to conclude by saying that marriage in Muslim law has different viewpoints regarding the marriage contract, civil contract, and the religious sacrament. But some of the famous jurists have given their different views. So but the 3 essentials of Nikah is a very important part without which a Muslim marriage cannot be held. So that's all for today, and looking forward to have such interactive sessions again. Thank you.